right, excellent, excellent. All right. Hello? Yeah. Okay. I don't think I need it for the for this room. Okay.
Are you ready? Good afternoon, everyone. Welcome to the Center of Comparative and Public Law Lunchtime Seminar Series. It's my pleasure and honor to introduce to you Professor Daniel Bodansky today. Professor Daniel Bodansky is a preeminent authority on climate change issues, and his teaching and research focus are on public international law and international environmental law. Professor Daniel Bodansky is the foundation professor of Sandra Day O'Connor College of Law at Arizona State University. Before that, he was the Woodruff Chair in International Law at the University of Georgia. He had served as the Climate Change Coordinator at the U.S. Department of State. Recently, he is also working with the Center for Climate and Energy Solution in negotiating with other senior climate change negotiators on the issue towards 2015 dialogue. Professor Bodansky is a graduate of Harvard College, Cambridge University, and Yale Law School. So Professor Bodansky today is talking to us on previewing the legal issues in the Paris Climate Change Conference.
I think I'll stand, just to move around a little bit. So thank you very much for that introduction, and it's a pleasure to be here today. What I wanted to do is provide a little bit of a preview of the Paris conference, but focusing in particular on the legal issues in the negotiation, because my background is as a public international lawyer, and that's what I'm going to be focusing on. So I'll start with a little bit of background on the UN climate change regime, just for those of you who haven't followed it closely, so where have we been and how do we get to where we are now. Then focus on the Paris negotiations. I want to spend a little bit of time on the issue about whether or not the Paris Agreement will be legally binding, what that means, what its implications are, does that make a difference. And then I'll spend a little bit of time on the issue of US joining the Paris Agreement. I know that's a little bit US-centric, but I think most people would say in the negotiations that US participation in Paris is going to be a necessary, even if not a sufficient condition for its success. So there's been a lot of international attention to the question as to whether or not the US can join, particularly given the fact the US is not a party to so many international agreements. Will that be true of Paris, or will the US be able to join it? So I like to describe the development of the climate change regime as a play in 4 acts. So the first act is the UN Framework Convention on Climate Change. The second act is the Kyoto Protocol. The third act is the Copenhagen Framework, and now we're in the midst of the 4th act, which is the Paris Agreement. So the UN Framework Convention essentially acts like a constitution for the climate change regime. It establishes the basic system of governance, the basic institutions, principles, a few general obligations, but does not require countries to reduce their emissions by any particular amount. So there are no emission reduction targets that are legally binding in the Framework Convention. It was adopted in 1992 and now is essentially universal in its participation in 195 countries, including, I should add, the United States, which was one of the very first countries to ratify. Kyoto Protocol, the second phase, second act of the regime. So the Kyoto Protocol was about adopting internationally binding targets on greenhouse gas emissions, and 3 features I just want to highlight in the Kyoto Protocol. First of all, they're internationally negotiated targets, so countries didn't get to choose their target. There was an international negotiation that led to the targets that were adopted in Kyoto. And countries' targets in Kyoto don't reflect necessarily what they would have preferred going into the negotiations. They were the result of a very intensive back and forth negotiation process. There's a market-based architecture, so countries can achieve their targets through the use of emissions trading and other market-based approaches that allow you to reduce your emissions in another country and get to count those emission reductions towards meeting your target. Second feature, legally binding. There are detailed rules about exactly what your target is, how you do the accounting for whether you met your target. There's a compliance system that's quite involved by international standards, at least, in terms of assessing whether or not you achieved your target or not. So the second feature, legally binding. And then the third feature, All of this just applies to so-called developed countries or Annex 1 countries that are listed in Annex 1. Developing countries, the mandate for the negotiations of Kyoto said there were going to be no new commitments for developing countries. So this system only applied to developed countries. So the third act, which began after the entry into force of the Kyoto Protocol in 2005, third act is the Copenhagen Cancun phase. I'd say the third act was largely about trying to increase the participation, make the approach global rather than simply focused on developed country emissions. And so it culminated in the Copenhagen conference, the Copenhagen Accord, and then Copenhagen broke down in some disarray, and so the Copenhagen Framework really was not formalized until the following year in Cancun in the so-called Cancun agreements. So the Copenhagen approach is essentially the, if you take the Kyoto approach on one hand, the Copenhagen approach is the opposite in each respect of the Kyoto approach. So Kyoto has internationally negotiated targets, whereas Copenhagen has nationally determined pledges. So instead of having international negotiations that determine what your emission reduction was going to be, in Copenhagen, each country just got to come forward and put forward their pledge as to what their reduction was going to be. These pledges were not legally binding in contrast to the Kyoto targets. But in contrast to Kyoto also, this wasn't a regime focused solely on developed countries. The pledges that were made under the Copenhagen Cancun framework were made by a very broad array of countries, representing a large fraction of global emissions. Other elements of Copenhagen I just want to mention, in addition to this core feature, Copenhagen involved putting significantly financial resources on the table, so developed countries pledged to mobilize $100 billion per year on climate finance by 2020. It also set for the first time an international goal for how much temperature increase would be acceptable. That's the 2-degree goal. So the purpose, the overall goal of the regime as adopted in Copenhagen and Cancun is to limit temperature increase to no more than 2 degrees above pre-industrial levels, no more than 2 degrees above pre-industrial levels. And then there are some new reporting and review mechanisms also part of the Copenhagen framework. So I think the Copenhagen Cancun framework is very important because it now is trying to address emissions not just by developed countries, by countries around the world. And you can see here how much the situation has changed from 1992 when the Framework Convention was adopted, or 1997 when the Kyoto Protocol was adopted. Yeah, I'll just go over here. So in 1992, US-EU dominated in terms of emissions. Even in 1997 when Kyoto was adopted, still largely a problem of Western developed country emissions. But now in 2010, China is now by far the biggest emitter. India's emissions have come up significantly. So you're not going to be able to deal with the climate change problem unless you deal with global emissions, not just developed country emissions. So the Copenhagen Cancun framework is largely about trying to figure out an approach that could be applied more generally that would have a global coverage. So we're now in Act 4, which is the Durban Platform negotiations. This is named after the Durban conference where this negotiating mandate was adopted. And it's supposed to culminate next month in Paris with the adoption of some kind of outcome in Paris. And the specification for the Durban Platform negotiations is to launch a process to develop a protocol, another legal instrument, or an agreed outcome with legal force under the convention applicable to all parties. So just want to flag here initially a couple of features of this. First of all, applicable to all parties. So this is, again, like Copenhagen Cancun, supposed to be global, not simply a developed country kind of agreement. And then the form of the agreement, protocol, another legal instrument, or an agreed outcome with legal force. And I'm going to come back to that. This was the product of hours and hours of negotiation, if you can believe it. The negotiations are supposed to finish, the meeting was supposed to finish on Friday, as has now become just the norm in climate meetings. The meeting went to Saturday. Everybody expects now the meeting to go to Saturday, but in Durban, they still couldn't get an agreement on Saturday, so it went to Sunday. It went to Sunday afternoon, and Sunday afternoon they still had no agreement about, because India in particular did not want a legally binding agreement coming out of Paris. Many countries, including particularly the EU, did want a legal agreement, and they could not come up with a formulation. Finally, on Sunday afternoon, the South African environment minister, who was chairing the meeting, it was being held in Durban, South Africa, she said, go off and just try to, get together. This is on the floor of the plenary of the meeting. Get together and try to work out. So there was so-called huddle, where about 50 people are all trying to jostling with each other, pushing and shoving, trying to negotiate the language. And out of this huddle came this phrase. And particularly the key here is or an agreed outcome with legal force, which nobody knew what it meant, so everybody could accept because they weren't sure if this meant a treaty or not a treaty. So as is common in these international negotiations, you try to come up with a formulation that is sufficiently unclear or you obfuscate it so much that everybody can find it, can basically argue that they won. Okay, and this agreement, as I said, is supposed to be reached by COP21. That's the Paris conference next month, and it's supposed to be implemented from 2020. So Kyoto dealt with a period up to 2012 initially. Then in Copenhagen and Cancun, they agreed to that framework applying from 2012 to 2020. And so Paris is now about the post-2020 period. And interestingly, the Durban Platform does not mention the principle of common but different responsibilities in respect to capability. That's been the basis for differentiation between developed and developing countries up until now, and the Durban Platform did not mention it. All right, so the question for Act 4 is which approach to adopt, a top-down regulatory approach like Kyoto or a more bottom-up pledge-based structure like Copenhagen, legally binding targets like Kyoto or a softer approach like Copenhagen, and then third, to what degree is there differentiation between developed and developing countries like Kyoto, or to what extent is it a more common approach like Copenhagen and Cancun? All right, and so I just want to spend a minute here on what the goal is. Apologies to Inya, who heard this talk this morning. Some of the parts of it, at least, are similar. So I define the goal here as environmental effectiveness, which is basically measured in terms of how much emission reductions you get from the agreement, and not just emission reductions at a single point in time, but emission reductions over time. So how dynamic is the agreement in terms of trying to produce bigger emission reductions over time? And this is a function, most environmental NGOs involved in the negotiation, I think, have traditionally thought about this question of environmental effectiveness as how stringent are the targets, how stringent are the emission reduction features. But I think as the Kyoto Protocol illustrates, how effective the agreement is not simply a matter of how ambitious the commitments are. It's a function also as to who participates, which countries participate, and which countries comply, because you can have a very strong agreement, but if countries aren't participating in it or they're not complying with it, then you don't have much actual emission reductions. And the problem becomes very complicated because these variables, to some degree at least, are interdependent. The higher the ambition of the commitments, the more likely is it that some countries aren't going to want to participate, or even if you can convince them to participate, they may not be willing to comply. So you're trying to solve an equation where there are three interdependent variables, and you're trying to find the combination of values for those variables, the ambition of the agreement, the level of participation, and the compliance level that yields the biggest outcome, which is reductions in emissions. Okay, and then finally, just by way of backdrop, so how many of you are you all international lawyers by training? Some international? Okay, a few. All right. So the question here is a general question for international law, which is what role can international law actually play in changing behavior? How does international law play a role in changing behavior? And I think it's worth thinking about this question because it then has a big effect on what you think the Paris Agreement realistically can do. And so I distinguish here between three models as to what the international law, how it could work. So the first is a prescriptive model. So this is the model largely of domestic law, where you can legislate rules and then you can prescribe those rules and then require people to follow those rules. And basically, because you have enforcement, you can force people to follow the rules. The second model is a contractual model where you get agreement, reciprocal exchange of promises that's memorialized in the contract or in the treaty. And the third model is a more facilitative model where you're trying to not require action or even contract for action, but you're just trying to encourage and nudge countries along. So let me just very briefly describe these three models. So the prescriptive model is basically law as a hammer, where you're trying to get people to change their behavior. You're prescribing rules and then forcing them to change their behavior. And law generally can produce winners and losers. So it's not the case that everybody's going to come out ahead if you pass a new piece of legislation. The law can be redistributive, can redistribute goods from one person or one entity to another. And why would the losers go along? Well, they might not like it, what the laws provided, but if you have enforcement, you can force them to comply with the law. And the problem internationally is that international law, in my view at least, is a super small hammer trying to drive a very big nail, which is human behavior. So you think about what contributes to climate change. It's the energy we consume, it's the goods we consume, it's transportation, it's the food we produce from agriculture. Basically, huge parts of countries' economies, in fact, virtually every human activity is producing greenhouse gases to one degree or another. So you're trying to change whole economies from where they are now to some different decarbonized state. So you're making fundamental changes in countries' economies, and you're trying to accomplish that or effectuate that through international law, which is a super, super little hammer because it has very, very little force behind it. When people make proposals for Paris, and this commonly you hear, proposals where some countries are going to basically come off worse out of Paris, and then other countries are going to gain. There's going to be massive amounts of financing from developed to developing countries, for example. The most prominent example, when I say, well, why would developed countries agree to that? What are they getting out of the agreement that would lead them to part with huge amounts of money? And people say, well, but the agreement will just require them to do that. And I think, well, why would countries agree in the first place? Why would countries agree in the first place? Or even if they agreed, how likely is it that they're going to comply? How likely is it that they're going to follow through? Even if you say, as many people say, all the world's eyes will be focused on Paris, and countries won't want to obstruct agreement, and they'll feel pressure to agree to an agreement, even though the agreement leaves them worse off. I don't think that's true. I don't think countries will feel that much pressure. But even if it were true, there's the question as to whether they would actually follow through when push comes to shove, whether they would actually comply. So the model that international law usually is based on is the idea of contracting models. So treaties are contracts between states. And the theory, of course, of a contract is that through a reciprocal exchange of promises, both sides come out ahead. That's why you enter into contracts. You give up something in exchange for somebody else giving up something, and those exchanges produce benefits to everyone. And that's why people agree to contracts, or why countries agree to treaties, is they're going to come out ahead. So it's basically a concept of bargaining, like getting to yes, where you're trying to find win-win solutions where everybody comes out ahead. And the precondition for a successful contract is that there is some contract zone where everybody feels there's an outcome that leaves them better off. There has to be some contract zone, some set of agreements that leaves everybody better off. And then the negotiations are about, among those different options within their contract zone, which of them you choose. So there's a collective gain from the contract, and the negotiation is about how to distribute that gain among different contracting parties. So the contract model, though, has not been working very well in the climate negotiations. Hasn't been working very well. The negotiations have not been, if there are win-win solutions, it shouldn't be that hard. You shouldn't have to go to Sunday morning or Sunday afternoon every single time, practically, or Saturday at least. It shouldn't be that hard. And I think the contract model isn't working because in most countries, climate change policy is driven by domestic politics, not by international politics. It's such an important part of domestic politics that there are very few countries that are actually willing to do more in exchange for other countries doing more, which would be the basis for a contract. The EU, in their original submission for Copenhagen, said we will reduce by 20% on our own, and we'll reduce by 30% if other countries reduce. So they are taking a contracting approach where we're willing to do 20% unilaterally. We feel that's in our interest, but we're willing to do another 10% reductions in exchange for reductions by others. So they're following the contract model, but no other country's really taking that approach where we're willing to do X on our own, and we're willing to do X plus Y in exchange for reciprocal promises by others. And I think that's because what your climate policy is, your X, that's all you can do. That's all the domestic politics allows you to do. Whatever your number is, it's not that you're going to be able to do more in exchange for other countries doing more. So this leaves us as the only real option, in my view. It's not a great option, but it's the last one standing as a possibility, what I call here a facilitative model, where the idea is that states are willing to do something, they're willing to do an X amount of reductions, they're willing to do something, but the problem is they might not even be able to get to that number on their own. They need to be encouraged, they might need assistance. So you're basically trying to facilitate and make possible countries to do as much as they feel they domestically are able to do. And that's basically, in essence, what the climate change regime is trying to accomplish. It may not be a huge amount, but the idea is hopefully it's better than nothing. Okay, so lessons learned. So Kyoto had a relatively strong system, but with very limited participation. Copenhagen, bottom-up approach, much broader participation, but low ambition. So that's showing, contrasting. Kyoto's in the dark blue, relatively few countries participating, only covered initially about a quarter of global emissions. The second commitment period of Kyoto is only covering 13% of global emissions, so a very small fraction of global emissions are being covered here by the Kyoto countries, and now, Australia's dropped out. Oops. Australia's dropped out. Yeah. All right, so there's smaller and smaller coverage, whereas Copenhagen, Cancun includes the countries with dark blue, and then also the countries in the lighter shades of blue with different kinds of Copenhagen pledges. So much broader coverage, but the pledges don't add up to enough. So this is showing a pathway that would keep us to less than 2 degrees, the green pathway. That's the global goal that's been agreed on in Copenhagen, no more than 2 degrees temperature increase. So we need to be, now of course, this is just a pathway. There's, you can assume a bigger amount first and then bigger reductions later on. But this is trying to do modeling to show what is a realistic pathway to get to 2 degrees. And so you need to be within this, in this green band. And so for 2020, which is when Copenhagen is, when Copenhagen is dealing with the 2020 period, that black square is what the Copenhagen pledges would accomplish and puts us in the red zone. So it's somewhere between 3 and 4 degrees temperature increase rather than less than 2 degrees. So you have very broad participation but inadequate ambition. And so this has led in the context of Paris to the notion of having a hybrid approach, which combines some bottom-up flexibility to encourage participation, but with some kind of international rule structure to promote ambition. So you want to have some combination of these two approaches. And that's essentially what Paris is now trying to accomplish. You have nationally determined contribution, or NDCs as they're being called. These are what countries come forward with and pledge that they're going to do to reduce their emissions, and that's the centerpiece of the Paris Agreement. So that's the bottom-up flexibility part. But in contrast to Copenhagen, you also have a set of multilateral rules that are internationally agreed upon in the Paris Agreement that would provide some discipline. So it's not that countries can, anything goes. There's some discipline about countries' pledges. There's some rules about transparency and accountability so that you can actually look and see, this is what countries said they were going to do, this is what they've done, have they followed through, have they lived up to what they said they were going to do in the Paris Agreement. Okay, and so the structure of this is likely to be a core agreement, a package with a number of different elements, a core agreement, some kind of ancillary instrument to house the NDCs, countries' pledges about what they're going to do to reduce emissions, some set of COP decisions spelling out in more detail the rules for how the system will work, and then possibly a political declaration. And this is really more of a fallback option where if you can't get agreement, if some countries are blocking, the countries that want to do something can adopt a political declaration like they did in Copenhagen. And so this is what it is looking like. You have a central COP decision that adopts the Paris Agreement, that recognizes the INDCs, the intended nationally determined contributions that have been put on the table so far, some decisions elaborating the agreement, and then under the Paris Agreement there would be some ancillary instrument that would house the final nationally determined contributions that countries make. Okay, so that's by way of background. So now let me turn to the legal issues in the negotiations, because that's what I want to focus on in the remainder of my time. So I try to phrase them in terms of 10 propositions. And so there have been now 3 legal expert meetings among the government lawyers in the negotiations. And so these are not official meetings. There actually is not an official legal expert group as part of the negotiations. So in some negotiations, there is a legal committee formed, and in climate negotiations, nobody wants to empower the lawyers enough by forming a legal group. So these meetings have all been informal meetings. They've all been, in a sense, offline meetings. But they've involved the lawyers from, I'd say, many of the key countries, if not all. So they've included lawyers from most of the Western countries, Europeans, Australia, New Zealand, US, as well as lawyers from many of the major developing countries, including, for example, China. So, although there's some key countries that have not participated in any of these meetings, such as India. So it's a little unclear how much this represents a true consensus among the lawyers, what I'm going to say, and how much this represents, as a function of who participated in these meetings. Everybody participated in these meetings in an unofficial capacity, so nobody's bound by these positions. But nevertheless, I think what these 10 propositions try to do is distill, I think, an emerging consensus among countries on some of the key legal issues in the negotiations. So the first 4 propositions deal with the legal form of the outcome in Paris. What is the legal form of the Paris outcome? And so this is trying to elaborate this notion of the Durban Platform that I mentioned, that the parties are to develop a protocol, another legal instrument, or an agreed outcome with legal force under the convention applicable to all parties. So the first proposition is that the Paris outcome must include an agreement that falls within the scope of the Vienna Convention on the Law of Treaties. So the outcome will need to be a treaty. And the Vienna Convention on the Law of Treaties defines a treaty as an agreement in writing between states governed by international law. That's the definition. I've used this formulation because treaty has a different meaning in US domestic constitutional law. A treaty in US constitutional law is an agreement that gets the advice and consent of 2/3 of the Senate. That, in fact, as I'll get to in a little bit later, is a subset of international agreements or international treaties. It's defined by the Vienna Convention on the Law of Treaties. So COP decisions, there was a period of time after Durban when some countries were arguing that simply having a conference of the party decision in Paris would be enough to satisfy the Durban Platform, but I think no country's taking that position currently. If you look at the draft negotiating text for Paris, it clearly is a treaty within the meaning of international law. That's going to be the outcome. What kind of treaty is it going to be? Well, the UN Framework Convention provides several bases for the COP to adopt a legal instrument. It could be an amendment, annexes, protocols. It can be an unspecified kind of agreement. Some countries find the word protocol, I won't mention who, but find the word protocol to be politically toxic. So there's a significant opposition by at least one country to calling this the Paris Protocol, which was what some countries originally wanted to call it. So I think it's likely to use a neutral phrase, Paris Agreement. But the Paris Agreement, even though it's not using the protocol word, is still, in essence, a protocol and a treaty in international law. So this is related to the previous, since some countries care what term is used to describe the Paris Agreement, it's likely that the COP will not specify under what basis they're adopting the agreement, to lead every country to say that it's being adopted under a different basis. Because again, this is very politically sensitive, how it's adopted. Now, as a matter of international law, it makes no difference how it's adopted. It's still a treaty in international law, but there's a lot of political overtones to adopting it one way versus the other. So in all likelihood, the COP will simply adopt the Paris Agreement in Paris, but will not specify what kind of agreement or on what basis they're doing so. This is the depths to which the climate negotiations have sunk, but these are huge issues actually politically now in the negotiations. And so the title of the agreement is likely to be an agreement. China has proposed that it be called the Paris Implementing Agreement because they would like to tie this agreement as closely as possible to the UN Framework Convention. Why do they want to tie it to the UN Framework Convention? Because the UN Framework Convention has an annex structure that separates developed and developing countries. So they would like to, by implication, tie this as closely to that structure as they can. Developed countries, conversely, would like to keep this agreement as far as possible away from the UN Framework Convention so as not to be bound by that division between developed and developing countries. So there's now an issue as to whether to call it the Paris Agreement or the Paris Implementing Agreement. Again, no significance legally, but in terms of the political overtones and how closely this is under the convention and how separate it is from the convention, again, implementing agreement makes it sound like perhaps more of the convention's structure will be part of the new agreement, whereas if it's just the Paris Agreement, it has more of its own, stands at its own two legs in some sense. So the fifth proposition has to do with the character of specific provisions. And so there are a whole series of different provisions now relating to nationally determined contributions and finance and adaptation in the Paris Agreement. And some of these are procedural types of provisions. So countries would have to submit an NDC. They would have to provide information about their NDC, their nationally determined contribution. They would have to provide information about what they're doing to implement their nationally determined contribution. So various procedural kinds of provisions. And then also perhaps communications about adaptation efforts, about finance, and so forth and so on. And then there's the potential for substantive provisions. For example, that you have to implement your NDC. You don't have to just report about what you're doing. You actually have to implement your NDC. You have to achieve the reduction that your NDC calls for, or that you have to provide a certain amount of money on finance. So they're both procedural and substantive provisions. So the Proposition 5 is about the legal character of these provisions. The Paris Agreement, even though it's a treaty, and so as a matter of legal form, it's an internationally binding agreement, it could include provisions that are not themselves legally binding. This has become also a big issue because European lawyers say a treaty is binding under international law, and under the rule of pacta sunt servanda, treaty provisions are automatically binding. But it's also the case that many treaties include non-binding language. They use the word should or aim or goal. They don't use the language of an obligation like shall. And so I think while I agree that there is the rule of pacta sunt servanda, obviously, which is treaties must be obeyed, you still have to look at the specific language of each provision to see what the legal force of that provision is. And so countries have a lot of ability in the negotiations to modulate the legal force of provisions in a treaty through their choice of language. And so there's actually a range as to how legally binding provisions will be. And this has now become an issue as to, for each provision, if you look at the negotiating text, virtually every single paragraph in the negotiation text has in brackets shall and should, because on every single issue, there's a question about whether it should be legally binding, where you use the word shall. A country shall report, a country shall implement, or do you use the language not of a binding nature, where it should, where you're just basically recommending, not requiring. And so this is now throughout the entire text, and so for each of these provisions, there's going to need to be a decision about whether to try to make it legally binding or not. And so countries have a lot of, even though it's a treaty, a lot of ability to modulate the legal force of the agreement through their choice of what verb they use to introduce each particular provision. Now, the issue where this is the most prominent is with relation to nationally determined contributions. The question is whether nationally determined contributions, what countries say they're going to do to reduce their emissions, whether those should be legally binding or not. Some countries think unless they're legally binding, it's not going to be a very credible agreement. Others find that very difficult. And then there's this related question about whether or not the NDC should be part of the agreement or should be somehow sort of alongside the agreement. And so many countries have taken the position initially that you need to have the NDCs in the agreement because you want to make them legally binding. And so but the lawyers have now, I think, come to some consensus that it doesn't matter whether the NDCs are in the agreement or out of the agreement in terms of their legal character. What matters is what the treaty says your commitments are with relation to your NDCs. So it's the language about your commitments with relation to the NDCs that will determine the character of the NDCs, not whether they're in or out of the agreement. Nevertheless, this issue about do you put the NDCs as an annex to the agreement, so they're part of the agreement, or do you keep them outside the agreement, may have some significant practical implications. So one country in particular, I should say not the US in this case, says they don't want the NDCs housed in the agreement because if they're in the agreement, then they will have to be, in a sense, ratified. When you ratify the agreement, you ratify everybody's NDCs, and they don't want to do that. So there's some issues about whether to house the NDCs in the agreement that are not about their legal character, but may have other ramifications. I think it's likely the NDCs will not be part of the agreement. They'll be in a registry or website maintained by the UNFCCC, but they won't be an integral part of the agreement. Eighth proposition has to do with the meaning of the words under the convention, which is in the Durban Platform, that the new agreement is going to be under the convention. So some countries would like to tie this very closely to the Framework Convention, because the Framework Convention has this structure dividing Annex 1 developed countries from non-Annex 1 developing countries. Developed countries don't like that structure, so they would like to keep some distance here. So does the Durban Platform require continuation of the UNFCCC Annex structure, since the Paris Agreement is under the convention? And I think there's some agreement that the Paris Agreement is adopted under the Framework Convention. It can't be inconsistent with the Framework Convention, but it doesn't have to follow the same structure as the Framework Convention. The Framework Convention has 3 provisions that explicitly say they apply not simply to the Framework Convention, but they apply to related legal instruments. So this will be a related legal instrument. Those provisions of the Framework Convention that apply to related legal instruments apply to this agreement, because this agreement is under the convention. Those are relatively modest provisions. The objective of the convention applies also to related legal instruments. But principles like the principle of common but differentiated responsibilities in the annex structure, are relevant to the Paris Agreement, but they don't have to directly apply and be incorporated into the Paris Agreement. In terms of institutional arrangements, the Paris Agreement could use the same institutions as the UNFCCC or create new ones. In some contexts, in some environmental regimes, related legal instruments like protocol create new institutions and new conference of the parties and so forth. In other cases, they use the same institutions, and parties have flexibility on that question. And then finally, on entry into force, this is an issue, again, that may seem modest, but it becomes important. What are the requirements for this to come into force? And it could be a specific number of countries. That's the typical approach taken in international law. But I think it's likely that in addition to a minimum number of countries, there's going to be some emissions threshold, because you need to have a certain amount of coverage of global emissions to make the agreement credible, and countries aren't going to want to be bound by the agreement unless there's sufficient participation by other big emitters to make the agreement meaningful. Okay, so I want to just spend a little bit of time focusing on this question about the legal character of NDCs, because this is a matter of more general interest than simply the climate negotiations. So a lot of countries and other groups, civil society groups involved in negotiation, feel that it's very important that NDCs be legally binding, that countries have an obligation either to implement their NDC, their nationally determined contribution, or to achieve. And so actually there's been quite a lot of research done about whether the legal character of an agreement or an obligation matters. And it's quite inconclusive to try to actually determine how much difference this makes. But there are a number of theories as to why it might improve compliance. First of all, if it's a legally binding agreement, it's likely that there's more domestic buy-in, because you need to have there's a broader process for joining the agreement. I think there's a stronger sense of internal obligation. If it's binding, officials feel more obliged to follow something if they've legally committed to it than not. That's certainly the theory of most law, I think. There are greater reputational costs for violation, because it's not simply that you feel more of an internal sense of obligation to comply with law. You also feel other countries have a stronger requirement to comply, so that if you violate a legal obligation, it's more, you suffer more in terms of reputation than a non-legal agreement, non-legal provision. And if you have courts, the provisions capable of judicial application, if a court with jurisdiction exists, which in most cases internationally does not happen, so that's, I think, less important. Now, how strong? I think these are all plausible arguments. It's been very, very difficult to actually measure how important these effects are. The strongest indication that the legal character of an agreement matters is that states think it matters. States spend a lot of time negotiating the legal character of agreements. So why would they be expending all that energy? Why would they be so concerned about adopting a legal agreement if really the legal character of the agreement made no difference. I think it's hard to really explain why countries are so concerned, unless you think some of this is true, that countries are concerned about adopting a legal agreement, a legal obligation, because they think if they violate it, they're going to suffer more than if it's simply a political agreement. They're much more willing to adopt a political agreement than a legal agreement. Why? Because the legal agreement is going to be more costly. They're going to feel more pressured to comply. So I think this is all true to some degree, but the key is how much does it matter? Because I think there are two factors that cut the other way, that if it's legally binding, then some countries may not be able to participate, and then countries may come forward with less ambitious contributions because they want to make sure that they're able to comply. If they're worried about non-compliance because it's legally binding, they're going to have very unambitious commitments to make sure that they're not in a situation of non-compliance. U.S., for example, their contribution they came forward with, as I understand it, they think is a stretch. They think they can get there, but they're not 100% sure. If they were legally committed to achieve their target, they probably would have come in with a lower number to make sure they had some leeway, where if everything didn't work out exactly as they thought, they still would be within their number. So on the one hand, legally binding can improve compliance. On the other hand, it may lead to less participation and ambition. So there's trade-offs in terms of the legal binding character of nationally determined contributions. And I think the other thing to keep in mind is that if you're worried about compliance, which is really why countries are pushing to make nationally determined contributions legally binding, there are other ways you can try to promote compliance apart from making the provision legally binding. You can have more precise obligations, because if it's more precise, I think it exerts more, again, more guidance on behavior. It's more clear that you violated if it's a precise obligation than a non-precise obligation. And if you have transparency and accountability mechanisms, which actually require countries to come forward with information and be reviewed, even if it's not a legal obligation, that system of naming and shaming can exert pressure also in favor of compliance. So on the one hand, legally binding may improve compliance. On the other hand, there are other ways of improving compliance too, and there may be some cost to legally binding. So let me just close with the issue about U.S. acceptance of the 2015 agreement. So the U.S. has a fairly sorry record of joining international agreements. We're not a party to the UN Law of the Sea Convention. We're not a party to the Rights of the Child Convention, the International Criminal Court Statute, the Kyoto Protocol. So a lot of question about whether Paris is going to be more of that the same, whether the Paris Agreement, even if it's adopted in Paris, and I think there will be an agreement adopted in Paris, question about whether the U.S. will be able to join it or not, particularly given the fact that the Republicans in the U.S. control both the Senate and Congress, and so they're very unlikely to approve the Paris Agreement. So first of all, if the Paris Agreement were political in character, then there would be no issue about the approval process because it wouldn't be a legal agreement. I think that's now, we're beyond that. It is going to be a legal agreement, so it's not going to be like Copenhagen Accord, where President Obama could simply join it. Copenhagen Accord, and nobody questioned that because it was simply a political arrangement. But I think the important thing is that U.S. law provides a variety of ways by which the U.S. can become a party to an agreement. They can go to the Senate for advice and consent by 2/3 vote, but they can also be adopted with the approval of Congress rather than the Senate. They can be adopted pursuant to an existing treaty, and then they can be adopted by the president on his own, relying on his existing legal authority. And the president gets to choose which of these options to do. The president decides, does he just join the agreement? Does he send it to Congress for approval, or does he send it to the Senate for approval? And regardless of which of these options is chosen, internationally, the status of the agreement is the same. The choice of domestic approval options in the U.S. makes no difference to the international legal character of the agreement. So it's not the case that international agreements have to go to the Senate for the U.S. to become a party, or even have to go to Congress for approval. In some cases, the president can adopt them on their own. The question is, under what circumstances can the president do it on its own, and does the Paris Agreement will fall within those So Article 2 treaties, those are the ones that require the advice and consent of the Senate by 2/3 majority. Most multilateral environmental agreements have been adopted as treaties. Even if it were adopted as a treaty, it wouldn't be directly applicable by courts in the US. And there's a doctrine called the Self-Treaty Doctrine. Congressional executive agreements, that was the second kind of agreement I mentioned. These are approved by Congress, not by the Senate. The approval can come either in advance or after the fact. The vast majority of agreements to which the US is a party were not approved by the Senate. They were approved by Congress by a simple majority vote, including the World Trade Organization agreements, NAFTA, many of the most important agreements to which the US is a party. So this is the most common way. The most common way the US becomes a party to an agreement is not through Senate action, it's through congressional action. And it's easier to get, well, it may or may not be easier to get congressional approval than Senate approval, but in the case, for example, of NAFTA, they did not get 67 votes in the Senate, so NAFTA could not, that's the North American Free Trade Agreement with Mexico and Canada, would not have been approved as a treaty by the Senate, was approved by the Senate and by the House of Representatives, and was adopted as a congressional executive agreement. As I'll mention in a minute, it was challenged in the courts as to whether or not it should have gone to the Senate, in which case it would have failed, and the courts refused to hear the case. So largely interchangeable with Article 2 treaties, Senate-approved treaties. The President has pretty much, I think most people would say, pretty much complete discretion as to whether he sends the treaty to the Senate as an Article 2 treaty that requires 2/3 approval, or whether he sends it to Congress for approval. So I think the problem with Paris is it's not going to be approved by the Senate, and it's not going to be approved by Congress. So these first two options are not possible. So really the only basis on which the Paris Agreement could be joined by the US is the presidential executive agreement. And the president basically accepts agreements based on his existing authority without having to go to Congress or the Senate. The boundaries of presidential authority are uncertain as to what the president can do here. Supreme Court, though, has never struck down an agreement the president has joined. And there have been several cases now where people have challenged the president's decision to join a treaty, and the Supreme Court in those cases have upheld the president's authority. Some multilateral environmental agreements have been adopted in this way, so not all of them have gone to the Senate or Congress. The president has simply joined some agreements on his own, including the Long-Range Transboundary Air Pollution Convention, which deals with acid rain in Europe and North America. And then very recently, there was the Minamata Mercury Convention. So this is a convention dealing with limits on mercury emissions and production and consumption of mercury. U.S. was the very first country to join that agreement. It was the very first. Well, how could the U.S. join the agreement so quickly? Because President Obama simply joined the agreement. He didn't go to Congress. He didn't go to the Senate. So he was just submitted the U.S. instrument of acceptance of Minamata, and we were, when it comes into force, we will be a party to Minamata. So this approach has been used in other contexts, and so far it's never been struck down. So the question is, could it be used for the Paris Agreement? And the administration, this has become a big issue now domestically in the US because the Senate doesn't like this idea. Obviously, they would like to be able to they would like this treaty to go to them. So the administration's position is we can't say whether we'll do it on our own or not because it depends what the treaty provides. If the treaty allows us to join on the president's own authority, that's an option. But if the treaty includes provisions that require going to the Senate or Congress, we'll send it there. So if it includes a legally binding emissions target, if the NDCs are legally binding, then I think it's likely the president would not have the authority to join the agreement on his own. That's why this is such a big issue for the US. Because when the US joined the Framework Convention back in 1992, both the president and the Senate basically agreed that if a future agreement had an internationally binding emissions target on the US, it would go to the Senate for approval. The Senate. So it would be very difficult now for the president to join an agreement that had a legally binding emissions target for the US and not go to the Senate, given this past understanding. And I think if the agreement did include a legally binding NDC, then the existing precedents like Minamata and so forth, this would be exceeding those precedents. So this would be a more stronger assertion of presidential authority than we've seen up until now. So I think it's likely that if the NDC is legally binding, that would make presidential approval on his own without going to Congress very difficult. Maybe not impossible, but quite difficult. On financial commitments, there can be a lot of language on finance, but the bottom line is only Congress can appropriate money under the U.S. constitutional system. So if there were new financial commitments on the U.S., again, the president would have to go to Congress to get approval of that rather than be able to join on his own. On the other hand, if the agreement is largely procedural in nature, so the U.S. has to submit a nationally determined contribution, countries have to report, provide information, show up at review conferences, update their NDC periodically. That kind of agreement, I think, the president would be able to join on his own, because basically it largely would simply be elaborating what the UN Framework Convention already provides, which the Senate has approved. The commitments are consistent with existing U.S. law and in a sense, complement U.S. law. And the president has some independent constitutional authority over foreign affairs, and I think a procedurally oriented convention would largely be within the president's independent constitutional authority. Could the president's decision be overturned by courts or a future president? By courts, difficult to overturn, no matter what the president does, because the courts have traditionally stayed out of this kind of question, arguing that it's a political question, how the president joins a treaty. It's not a question, it's a judicial question the courts will review. And then you also need, under the doctrine of standing, you need to find a plaintiff who is directly injured by the decision. And it's very difficult to show that joining the Paris Agreement directly injures anyone, because the Paris Agreement, anything done to U.S. corporations or individuals would be under U.S. law. So it would be U.S. implementation under U.S. law that would be affecting corporations. A coal company couldn't say, we're injured by joining the Paris Agreement, because the actual, whatever injury a coal company might suffer from U.S. regulation of greenhouse gas emissions would be under U.S. law, under the Clean Air Act, and under EPA regulations, not under the treaty. So these two doctrines, I think, make it unlikely that the court would be able to reach a challenge. It would be hard to find a plaintiff to be able to bring a lawsuit, and there would be the political question doctrine. On the other hand, this Supreme Court has been willing to hear cases that I think many people thought they would not be willing to hear in the past. So it's anybody's guess as to whether they will actually follow these traditional doctrines or whether they will be willing to reach the merits of the case. So I would put a big question mark here, but I think at least the existing precedent suggests it would be difficult to bring a judicial challenge. Future president, though, could withdraw. So if if there was a Republican president who opposed U.S. participation in Paris, then a future president could withdraw. I should say, though, that's not only if it's adopted by Obama acting on his own. Even if this got approval, Paris got approval by 2/3 of the Senate or by Congress, the president still, under U.S. constitutional law, can withdraw from any international agreement. So this is a general problem with U.S. participation, not one that would be specific to the Paris Agreement. As a legal matter, the president has authority to withdraw. As a political matter, it's quite difficult politically to withdraw from agreements to which the U.S. is a party. I think that would be true of Paris too, but it's not impossible that if the U.S. joined, the U.S. would then withdraw under a different administration. All right, well, that concludes what I wanted to cover, sort of some of the legal issues, both internationally and then some of the legal issues in the matter of U.S. constitutional law. So thank you very much for your attention.
We would like to open the floor for questions. Is there any question anyone would like to ask? Maybe I'll use my privilege as chair to ask the first question. You mentioned that in the Framework Convention, there's this differentiation between developed and developing countries, and China was very much hoping that this framework can be used in the Paris Agreement as well, so that they can receive the benefit of having the developing countries for attribution of responsibility on reducing CO2 burden. How likely do you think this framework between developed and developing countries would be adopted in the Paris Convention? And if not, what would be the alternative way of differentiating responsibility among different countries?
So the Framework Convention provides there's this principle of differentiation, and then it's essentially articulated in the Framework Convention, or implemented in the Framework Convention through having an annex that defines who's a developed country, and then everybody else is considered a non-annex one, or developing country. This is a division that was done at the last moment. It doesn't really reflect realities today in many respects, because I think 5 of the 10 richest countries in the world are non-annex one developing countries. There's a significant number of developing countries, that so-called developing countries, that are richer than many of the lower income developed countries. So a country like Bulgaria is not in the upper tier of per capita GDP, and yet they're considered an Annex 1 country. So, but I think in terms of the Paris outcome, actually on China, interestingly, China's moved tremendously on this issue. So the US-China joint declaration last year that was adopted when Obama was visiting Beijing does not mention the annex structure. It refers to the principle of common differentiated responsibilities and respective capabilities in light of national circumstances. So this new phrase, in light of national circumstances, was added to basically try to provide more flexibility, sort of reinforce the notion that this is not a rigid division between one group of countries and another group of countries, that you're basically trying to differentiate what countries are doing based on national circumstances, and as national circumstances change, as countries change, then the appropriate differentiation changes as well. So this is the new formulation that China has actually now agreed to, both in the US-China declaration, and then there was the joint communique from 4 days ago between France and China. So President Hollande of France was visiting Beijing, and they came out with a joint communique about the Paris Agreement that's basically and China again in that there's no reference to Annex 1, non-Annex 1. Again, it's based on this new principle. So I think with China, there's this new, there's not, I mean, they won't necessarily say that in the negotiations, but I don't think they're, I think they've given up on the annex structure. The question is whether all the other developing countries are willing to also go along with that, and so some of them, at least they've given no indication they're willing to go along with that. They like the annex structure, they like being a non-Annex 1 country. So I think the jury is still out as to whether or not this new approach will be acceptable to everyone. But interestingly, in Lima last year, at the last conference of the parties, the issue of differentiation was also very big, because there was a decision which people thought, rightly so, was setting the stage for Paris. It was the last conference before Paris. And there was a huge amount of disagreement as to whether you should mention the annexes and developing countries or not. And lo and behold, the compromise language in Lima is exactly the same compromise language that was in the US-China joint communique. So I think that language now seems to have been repeated in a number of different places. It seems to be. So I think the center of gravity of the negotiations is to essentially have a system of there will be differentiation. If you look at what countries have come forward with and say they're going to do under Paris, it's very different. Some countries have economy-wide absolute targets to reduce emissions. Other countries have intensity targets to reduce emissions. Some countries have reductions from business as usual trajectories. Some countries have economy-wide targets, other ones limited to certain sectors. So there's a huge amount of differentiation in what countries say they're going to do already. And that differentiation is reflecting what they think they're able to do, what they think they should do. So there's what's now called self-differentiation, and I think that self-differentiation is going to be informed by the principle of common or differentiated responsibilities and respective capabilities in light of national circumstances. But I don't think there's going to be any explicit differentiation. I don't think there'll be any, so there won't be lists, annexes, etc., in my view.
Okay, thank you. Thank you very much. Any more questions?
Hi, thank you very much for both presentations today. I was wondering if you could tell us a bit more about the place of market mechanisms within the Paris Agreement, and do you think that markets are actually effective? What's your view on this?
So I mentioned that one of the key features of the Kyoto architecture was markets, because even though the US didn't join Kyoto, the US pushed very hard in the Kyoto negotiations for a market-oriented structure, so countries are able to trade emissions allowances back and forth between each other. Developed countries can undertake projects to reduce emissions in developing countries and get credit towards their emissions target from the emission reductions in developing countries. so there's a very strong emphasis on markets in the Paris Agreement. European Union, which was quite skeptical of markets during the Kyoto negotiations, then has adopted an EU emissions trading system, so they have now embraced markets and internally in their own implementation of their Kyoto targets use an emissions trading system. So yeah, there is a big question about will the Paris Agreement continue this use of markets or not. And I would say when the Paris negotiations started, my expectations were relatively low for something on markets. It's a little unclear how markets would work if countries don't have binding emissions targets, if there's not some amount of emissions that you can define and say, you know, this is how much they have, and then they can trade some of that to other countries back and forth. It's a little hard to see exactly how it would work, but I would say at the moment, going into the last few weeks of negotiations, I think it's highly likely the Paris Agreement will have some umbrella provisions allowing for continuation of markets, because many countries in their nationally determined contributions specifically say it's conditioned on markets. I think the opposition to markets has maybe faded a bit. I'm not expecting any detailed provisions on markets, but essentially all you need is some provision that recognizes that countries can achieve their NDCs, their nationally determined contributions, including through linkages with other countries. So if the U.S. and, let's say California and Quebec now each have emissions trading systems internally within their, and now there's linkages between, so you can trade across countries. So if you have some recognition that countries can link their policies and achieve some of their nationally determined contribution through reductions in other countries, then I think markets will be still a strong part. And I'm expecting something like that to be included in the Paris Agreement.
Do we have any hope that national implementation in the states can be at least partially fulfilled at the state level?
So, as I understand it, in the development of the nationally determined contribution by the U.S., they included what they thought states were going to be doing. So, so it's not that the state action would be additional to what the U.S. number is. The U.S. number tries to reflect what they think, so it's a guesstimate. It's not but it's an estimate of what the U.S. reductions are going to look like in 2020, which is the year 2025. As a result of federal action, state action, and so forth and so on. So yes, I think, certainly whatever states are doing in the U.S. or cities or companies, and not just in the U.S., in any place, the NDC is a national emissions number, and so whatever's done to achieve that number, in a sense, counts, because what you're looking at is what the country said it's going to do as a whole, and what its emissions are, in fact, in the year, in the target year, and comparing the two. And so if some of that reduction comes about through action, not only by cities or states, regions, but also by companies, by sectoral initiatives among industry, all of that would still be counted in a sense in trying to achieve your NDC. That answer your question?
Yeah, sure. That feeds back into whether it's legally binding targets or not, because if you're relying on many actors within your society to achieve the goals, these are mostly goals that you wouldn't be able to enforce centrally.
Yeah, so in the U.S., the primary way the U.S. is conceiving and implementing its NDC is through the Clean Power Plan, which would be wouldn't be legally binding internationally, but it would be under the Clean Air Act and under EPA regulation. So which would then require states to develop plans to reduce emissions. So when you talk about, so some countries I think will do their implementation domestically through law, that it will be through domestic law. Other countries may not.
Just wondering how the Paris Agreement will interact with the existing financing mechanisms like the GCF and other commitments which have already been made.
Yeah. So the Paris Agreement is dealing with a period post-2020, and so the finance goal for adopted in Copenhagen deals with 2020, so it's mobilizing $100 billion through public and private financing to 2020. And then the GCF is obviously it's an ongoing institution. So I think it's likely the Paris Agreement will recognize the GCF as an implementing agency for finance. So the Paris Agreement will make use of the GCF, and whatever finance is provided under Paris will can go through bilateral mechanisms, channels, but also, or through the World Bank, but also through the GCF. So I think the GCF is expected to play, probably the key role on finance under Paris. But Paris will simply, basically, I think, reference the GCF as a financial mechanism for achievement of financial provisions in Paris.
We've had some cases of climate law, national climate law, running up against international trade law, and refusal to allow fossil fuels into a country is seen as an unfair trade practice. Is there any way that after Paris, in international environmental treaties, we'll have parity or even be able to counter the trade laws which work against some of the climate change and greenhouse gas provisions?
So I think there's zero prospect that the Paris Agreement will say anything about trade, except it may say something that countries will reinforce WTO rather than try to counteract WTO. So developing countries in particular are extremely opposed to the notion of imposing border tax adjustments or other trade measures against imports from countries that have higher carbon intensity or don't price carbon. So I see no prospect in Paris of doing anything to make it easier to impose trade measures. If anything, it might make it harder. But I think the issue about whether or not trade measures are permissible is an open question under WTO law. So as I understand it, there are some quite good arguments that there exists in WTO law that some kind of border tariff on imports based on the carbon content of the good, the carbon that was emitted in the production of the good, if structured in the right way, actually would pass muster in the WTO. So I think it's not likely that the climate agreement will, I think, move the needle one way or the other. I think it'll probably be silent on the issue of trade, and then to the extent countries do impose trade measures as a way to promote climate change policy, then it's going to be decided ultimately by the WTO dispute resolution body as to whether that's permissible or not. But I don't think we're going to see something like some of the multilateral environmental agreements that specifically provide for trade measures like the Basel Convention on Hazardous Waste or Convention on International Trade in Endangered Species, where you could say, or the Montreal Protocol that specifically provides for trade measures, where there's now been a tension between the agreement on the one hand and the WTO on the other, which prevails. In this context, I think there's zero chance that the UNFCCC will provide for trade measures. If anything, it might go the other way. But I think most likely it'll just stay silent.
I think it's about time. So please join me to thank Professor Bodansky for this excellent and insightful presentation.